we invited privacy law scholars to address a very important question, which is, what do we do with those 5 votes on the US v. Jones decision that seem to call into question the assumption of risk doctrine and more narrowly, the third-party records doctrine? And how do we address privacy in public under the Fourth Amendment after Jones? We were happy to get 16 great submissions from a bunch of the participants here. And folks from CDT, EFF, Future of Privacy Forum, and the Samuelson Clinic at Berkeley had the difficult but very rewarding job of picking 6 of them for lightning talk presentations here. So the 6 selectees will be spending 5 minutes on their proposal for what, if any, principle can you pull out of the Alito and Sotomayor opinions in US v. Jones, or one of them will be suggesting that you can't actually do that. I'll give you one guess as to who that is. So after that, after each 5 minutes, there will be time for 1 to 2 questions or comments. Greg Nojarm from CDT will be time enforcer. Do not mess with him. All of the papers are available. The presenters' papers are at your seats. There are also copies of the other papers at the table over there, and they are all currently available and will stay available at usvjones.com. One other unique feature of this part of the conference, all of these papers are public, therefore you can tweet or blog during this session about what is happening in this session. Consider using the hashtag usvjones.com. And with that, I will turn it over to our first presenter, Professor Blitz. Oh, we're going in alphabetical order.
You've all probably heard the story of, it turns out not to be true, of how you can boil a frog by putting it in a pot of water, and then very slowly, if you heat it up really quickly, it'll jump out. If you do it very slowly, the story goes, it won't be aware that you're heating it, and it will sit there and be boiled to death. It's not true, but it represents something true, which is that, as Dean Berman said earlier this afternoon, incremental violations of privacy can pile up without us recognizing what's going on. I think that the mosaic theory that featured prominently in the D.C. Circuit decision below, and then in the concurring, many people read into the concurring opinions, is a response to this. For various reasons, we'll hear much more about it later. That theory doesn't work very well, at least as a test. It's much harder to figure out when the crucial privacy violation has occurred than to figure out when a frog is about to boil to death. So if your theory is the court should jump in just as the boiling is about to occur, just as our privacy reaches a danger point, that's not, I think, going to be a helpful test. My proposal here is in the sense that the Constitution becomes relevant. The Fourth Amendment applies as soon as the government sets up the boiling apparatus and begins to turn up the heat. So even when you're at a very low temperature, even if ultimately, as it turns out, we don't get beyond a very low temperature, it's a search. The Fourth Amendment applies. To translate the analogy, I propose that as soon as the government uses a search technique, a form of surveillance that satisfies the following criteria. It's triggered by the state's interest in gathering information about a particular individual or individuals, and it has the capacity to systematically track or otherwise collect private information about individual movements or other activities that go meaningfully beyond the surveillance that's possible with unaided observation. An example would be the kind of tracking that occurred in Jones. Magnification, though, might also count as a form of public surveillance covered by this. That's a search. It's initial presumption. So the government can rebut it, but I don't propose that it should be easy for the government to rebut it. The government should rebut it only by showing that the form of surveillance is not what it looks like on first glance, that there's something built into it, is a part of the process by which the government acts that makes it very, very hard for government to invade privacy. So a couple of quick observations, because this is supposed to be lightning quick. One is that this should sound familiar in 2 respects. One is, as I noted in the proposal, focusing on the form of surveillance is something that Professor Anthony Amsterdam suggested a long time ago in a 1974 Minnesota Law Review article based on the talk. It also should sound familiar because I think Justice Sotomayor in particular, in her concurrence, repeats themes that are very, very close to this notion that you look at the form of surveillance and look at what the effect will be on a democratic society of leaving this unregulated. Now, that's not the test. The test that I gave, the presumption, focusing on whether or not police can track in ways that go meaningfully beyond unaided observation movements in public space, is a translation to make this practical. A few other observations. One is that, of course, police have to have freedom to gather evidence from public space. So maybe they won't be subject to a warrant requirement. Maybe it'll be a lower reasonable suspicion requirement. Or, as I say in the proposal, it may be the case that the court's test will allow much more room for the legislature to create safe harbors. So the police are still subject to a reasonableness requirement, but it's not as stringent a reasonable requirement as would come from a warrant. But the upshot of this is that I think the best promise for escaping the mosaic theory, it's not a mathematical formula or self-applying test, is to focus on the form of surveillance and its effects in a democratic society, and not on aggregating each step of information collection under the mosaic theory. Go ahead, Kevin.
All right. Jones and drones. Hypo, drone, following someone around for 3 days. Warrant or not, under your theory, and why?
It's a search. And whether or not a warrant applies, I was agnostic in it there, but I'll go further here and say I'd support a warrant in those conditions, and probably even if it weren't 3 days.
Would your articulation provide a rule that a judge could apply in deciding that? Or how should a judge apply your conception in judging that case?
Yeah, I don't think you need a drone-specific rule. I think that the reason that use of an aerial drone to observe somebody and monitor their movements counts as a search is because you have a search that's targeting an individual and has the capacity, right? I think once it starts to be used that there doesn't have to be an extensive inquiry into whether or not it went 3 days or 10 days or 20 days. I think that that's problematic. That if police targeted someone with a form of surveillance that had the capacity to track them through large portions of public space, that's the kind of thing that should be subject to constitutional restraint. That's not the kind of thing that the executive should be able to use, as Justice Sotomayor's concurrence suggested, free from any constitutional limits.
Okay, great. Thank you. Next up is Susan Freewald with her 4 factors.
Can you hear me? Okay. All right. Thank you. Thank you for choosing my paper. I have 4 factors, and here they are: hidden, continuous, indiscriminate, and intrusive. So those are my 4 factors. Where do they come from? In the 1967 Berger versus New York decision, when the Supreme Court considered electronic surveillance under a state statute, they decided that that surveillance was so hidden, continuous, intrusive, and indiscriminate that it needed to be subject to the highest level of judicial oversight to prevent law enforcement abuse. And those 4 factors were then used by 7 federal courts of appeals when they considered video surveillance in the 1980s, because silent video surveillance was not covered by the Wiretap Act, which had been passed in 1968. So I derived my test from those precedents where the courts, again, considered what type of surveillance was most in need of judicial oversight to make sure that law enforcement didn't abuse its power. And they chose those 4 factors, although they didn't explicitly call it the 4-factor test as I'm doing, because there are because those 4 features call out for judicial oversight. And let me talk about each one quickly. Hidden surveillance is the type of surveillance that is necessarily not subject to oversight in the moment by the target, which is as compared to, for example, a search of your home, which is necessarily going to be kept within limits because the target or his neighbors is there to make sure that things don't get out of hand. Continuous surveillance is a series of searches. So while the first search may be authorized or justified, it's not at all clear that searches over time retain that authorization or justification. Indiscriminate searches means you're using a technology to search where you're gathering up significantly more information than is incriminating. And of course, those kind of searches violate privacy more than ones that are specifically tailored, for example, a dog sniff for contraband. And intrusive searches is, of course, the most blatantly normative part of my test, but as I'll discuss in a minute, you can't avoid it. It's what the courts do. They make normative judgments. And intrusive searches are those that violate those Fourth Amendment values that we need to make sure that the judge oversees. So why is this a good test? I started to hint at it, which is it has a normative element. But in addition to that, it, like Marc's test, is a test that applies on a method-by-method basis. So I think Oren raises a good critique of the mosaic test, which is that if it depends on how many data points you get and you don't know that when you start, then it's really going to be difficult to implement for the police at the beginning. Whereas the four-factor test was applied to wiretapping as a technique, to video surveillance as a technique, and I think it should be applied to other techniques that share those features, those four features, and then that's going to be much more administrable. The other thing about it is, again, it is normative, and I've read the Katz decision, Justice Harlan's dissent in White 4 years later, where he said it is the job of the law to project. We have to make normative choices as judges. That's what judges are good at doing, about what are the kind of techniques that intrude on people's privacy in such a way that the judges have to oversee law enforcement to make sure they don't intrude on people's security and rights. So I think normativity is a feature, not a bug. But that the other aspects of the test, for example, the focus on things you can actually see, is it continuous, is it indiscriminate, is it hidden, reigns in the test more than a purely normative test, which would be sort of the vital nature test. The other thing is, I think that when the reasonable expectation of privacy test is done correctly, that the judges do come up with the right answers, and for an example of that would be the Warshak decision in the Sixth Circuit finding a reasonable expectation of privacy in stored emails, and that where the courts go wrong is where they use shortcuts to avoid the reasonable expectation of privacy test, like the third-party rule or content, non-content. How would it apply to GPS tracking and related techniques that don't have to involve a trespass to property or hidden? If they're not hidden, they're not as effective. They're intrusive, and that's a judgment call, but I would say that any kind of surveillance that takes place over a period of time, and a period of time is more, I would say, than a de minimis search. They're indiscriminate in the sense that you're going to rope in, and this is what the mosaic theory talks about, a lot of behavior that's not incriminating. It's quite different from a targeted dog sniff, and it is, what's my other test? Continuous. It goes over a period of time, and that's what makes it more indiscriminate. And so my test applies to GPS surveillance with or without a trespass. I've argued in the past it applies to stored email surveillance. I'm in the midst of arguing that it applies to location data in the cell site context, and now I am done, and I look forward to questions.
Questions for Susan? Oren's got one.
Oren's got one.
Susan, the four factors that you discussed from the Berger case were used in the Berger case to analyze the reasonableness of a search. And it seems here that you're using those four factors from the reasonableness of the search to instead answer what is a search. Isn't that a distinct question that has a different history, has a different doctrine? Sort of, how do you justify the jump from one box to the other box of the doctrine?
You know, I think we could talk a long time and more time than we have allotted to us about the trajectory with Fourth Amendment doctrine between the warrant per se requirement versus reasonableness as its own requirement. I think that reasonableness is in some ways a different way to look at the Fourth Amendment requirement. I think that ultimately the question is it a search? And if so, is it okay? In a way, I think that what Berger did And what the Berger Court did, and what the Katz Court did, and what the Supreme Court has to figure out is, does this technique, whether you want to call it reasonableness or not, require extensive judicial oversight, including a warrant and related techniques like minimization, notice, and that the four-factor test answers that question.
One more question or comment. Blake has a question or comment.
Hey, Susan. I really enjoyed your paper.
Thank you.
One question. You seem to identify, you look at these four factors as being positive because they focus on the surveillance methods and potentially make things more convenient for the police. And as I argued in my paper, I think that ought to be a secondary consideration. I'm wondering, to what extent these four factors do you think venerate the individual privacy concerns of citizens, and particularly innocent citizens?
Yeah, I don't think convenience of the police would ever be considered my value, because I think I push harder than most anyone, at least in litigation, for a standard that's very privacy protective. So I'm only saying that I agree with Oren's critique of a test that would require after the fact assessment of whether or not the test has been met is going to be really hard to administer. And so it's not that it's inconvenient for police, it's that it's actually hard for litigants. And I think, in fact, it's hard to vindicate rights unless you can say, you should have known at the beginning that you needed a warrant. So that's my problem with a test that says, 1 day is okay, but 2 days is not okay, because the police could always say, well, we thought when we started it was going to be 1 day, so, well, gee, it went to 2 days, but we thought. I mean, you look at the good faith rule and how it's used all the time. So I think that my test is definitely looking at the question of, in our society, when do we need the interposition of a judicial magistrate to rein in the police from using a technique that is particularly prone because of its features? It's continuous, it's hidden, it's intrusive, it's roping in all sorts of information that they don't have a justification for. It's particularly in need of the genius protections we have in our system, which is called judicial oversight, remedies, minimization.
Great, thank you. Blake, Ellis, Reed, thank you for the question and for the submission available on the site and printed out on the table. Next up, Jim Harper.
Hello, everyone. It's a great pleasure to be with you. I study privacy more than law, what it is, why people want it, what they do to pursue it. Sometimes colleagues of mine don't realize I'm a lawyer, and I take that as a very high compliment when they don't. But what is privacy? I'll talk about the control sense. You all work with that a lot. And how do people control information about themselves? Largely, it's using physics and law. When they go into their houses have a unique property of blocking photons from passing through the walls and blocking sound waves from passing through. So when you go inside and pull the curtains, what happens in there can't be seen. When you put on clothing in the morning, and you can thank me for having done so myself this morning, you're blocking photons from striking your body and bouncing off your body, reaching the eyes of others. You've protected privacy using physics, but not only physics. Obviously, when you go into your house, you're using property law to prevent others from coming in. They're relying on property law for that purpose. Likewise, putting on clothes, for example, you rely on the law of battery. Other people during the day cannot come up to me and take clothing off me in order to reveal the appearance of my body. If you understand how people protect information, you can apply physics and law to the problem of the Fourth Amendment. The Olmsted Court failed because it didn't recognize that a phone system translates the sound of a voice into a modulated electric current that is silent and invisible along the wire. In order to gather the sound of the conversation, they had to attach a wire, and Chief Justice Taft actually lied in the case, saying that it was the use of hearing and hearing only to listen to that conversation. Justice Brandeis pointed out the fact that there was wiretapping law in the state of Washington, and Justice Butler, who nobody pays any attention to, talked about the role of contract in protecting privacy of phone conversations. In Katz, it was entry into the glass phone booth that provided the defendant with protection for his conversation, and that's what the majority opinion relied upon. It was Harlan's concurrence that talked about reasonable expectations as a sort of backward reasoning. Well, instead of figuring out what the physics and law were with relation to this conversation, let's decide what's reasonable and move back from there. No, it's reasonable to expect privacy when you have used physics and law to protect information. And so thinking through these cases in terms of physical and legal protections is the way to do it. So I'm going to talk about the new search and seizure law. which is actually, I think, probably the old search and seizure law. But it's new because in Kelo and Jones, you have a case where there was a search in a high-tech environment, and there was a seizure in a high-tech environment. Kelo, you remember well from 2001, is the thermal imaging case. Justice Scalia said that the application of a technology, quote, not in general public use to explore details of the home that previously would have been unknowable without physical intrusion, is a search. The home uses walls to block sound waves, uses walls to block photons, and indeed walls block temperature as well. But using this high-tech device revealed something in a search. Black's Law Dictionary calls a search looking for or seeking out that which is otherwise concealed from view. Use those simple rules to determine when a search has occurred, understanding the physics and law that protected information. Jones is a seizure case, though unfortunately the court used the word search quite a bit. The doctrine that has developed over years limits seizure to possessory interests. But understand that the whole of property law includes not just possession, but the right to use, the right to manage, the right to sell, and the right to profit from your property. Obviously, using something as part of your surveillance enterprise allows you to profit from it. So it is, when you drop an RFID chip into somebody's coat pocket, it is a seizure. It is a conversion of that coat to your use, the use of law enforcement, and should be recognized as a constitutional seizure that triggers the question whether that seizure is reasonable or not. So let's fix the third-party doctrine primarily by recognizing the role of contract and regulation, laws that protect personal information and allow people to protect their privacy. A contract is how people deploy their property in mutual exchange for the benefit of others. So it is a property right that is invaded when the government tries to avoid contract and to avoid regulation. I can't quite solve the drone problem, and I'm not willing to bend the doctrine that I think the court is developing to go around and fix that. A drone, assume it's used in a public location without danger, for example, to the person who's being followed, is close to a search, but the barrier that controls personal information when someone is in public over an extended period of time, that's a permeable barrier. It's a barrier of time and distance. So I think it's a close judgment call. But you can certainly use Scalia, who turns out to be our friend in privacy, because he said technology not in general public use that reveals information previously would have been unknowable without physical intrusion is a search. Well, unknowable without physical intrusion in the past? That was attaching a GPS device to a car. So we have good precedent to go after the drone problem in the future. Thank you.
Thank you, Jim. Mr. Segoyan has a question.
I'm not responsible for killing people, Chris.
So I have a question about the general public use test from Kylo. You can now buy GPS tracking devices in the Sky Mall. You can build your own cell phone surveillance software and hardware for about $1,000. You can buy your own drone, and you can even build one if you're technically minded. And malware is so prevalent that many of us probably have it on our computers already. Not that we installed it there intentionally. The surveillance technologies that I'm the most worried about are widely available to the public now. So how is that test in Kylo going to be sufficient to keep the government from using things that I personally think no one should be using, but that are already out there?
That's a good question, and it focuses on an important point. Justice Scalia said in public use. And these things are there, they do exist. They're relatively exotic. We will come to a point where certain technologies will be so widely in public use that people can plan. They will be able to plan in light of those things. For example, the existence of Wi-Fi nodes, not actually being able to observe what the Wi-Fi traffic is, but the existence of Wi-Fi nodes is very, very common today because many cell phones and other devices pick up the fact of the existence of a node straight away. That's the sort of bleeding edge. The technologies that we're very familiar with that are in public use right now to enhance perception are things like glasses, the glasses you're wearing, flashlights, other technologies like that. Binoculars. You get some hard calls between whether somebody using very high-powered binoculars are perceiving what can be perceived, or are they using some outre technology in order to do a search. Those are judgment calls, and the question is a good one. But I think courts can handle those judgment calls dealing with facts and law much better than judgment calls about what's reasonable to expect in terms of privacy.
Time for one more.
Hi. I think there's at least one more thing that people tend to use to control their information, and you could call it obscurity, you could call it the failures of human memory, but it's not necessarily physics, like blocking light, it's not necessarily law, and leaving it out has the property of allowing license plate recognition, or drones, or all these things, the whole privacy and public point, where it's more about the collection and post-processing of data that you couldn't have had in time, right? That it is time shifted and collected and stored and later analyzed. Do you think? Did you mean to leave that out, or is there a reason for it, or is that? I mean, what are your thoughts on that?
Well, if I understand your question, I don't take as a given that the level of privacy people enjoy today, or the level of privacy they enjoyed 40 years ago or 200 years ago, is necessarily the level of privacy that they should have in the future. I share that genuine concern, and I admit I haven't fixed the problem that people can be observed in public, and that those observations can be agglomerated together to create records about them. And those records have many benefits. Those records have many costs. So I didn't leave that out, but I don't know that there is doctrine. Imagine a contrary rule, however you were to try to import it into the actual words of the Fourth Amendment, that a person had a right to prevent the government or just other people from collecting information, true factual information about their presence in places where they can be observed. This runs up against another important amendment of ours, the First Amendment. True facts about people are real, and there's constitutional protection for them. I have a hard time trying to use the Fourth Amendment to degrade the value of the First Amendment. I take it you disagree, and that'll be a disagreement.
So on that note, we are going to have to move on. Perhaps we can discuss this in the wrap-up questions. Next up, Oren Kerr.
So the traditional method of Fourth Amendment analysis has been at the first stage for courts to say government conduct is either a search, it violates a reasonable expectation of privacy, or it's not a search, it doesn't violate a reasonable expectation of privacy. The concurring opinions in Jones suggest a third answer, which is sometimes it violates a reasonable expectation of privacy, sometimes it doesn't. Depends on how you look at it. If you aggregate it in a certain way that we're not really sure about, but maybe someone can eventually figure out someday, maybe at a conference like PLSC. I gather the purpose of this meeting is CDT and EFF and the other individuals who put together this panel thought that if you had law professors submit their proposals for how to implement this new approach, we could have the solution. And if I recall correctly, there's actually a press conference scheduled in which the proposal, the solution, will be announced based on the submissions received for this panel. Well, it was interesting that actually, as I count it, none of the proposals offered a way to implement this mosaic approach, this sort of middle ground approach, and to instead go back to the traditional question that we've always asked, is the government conduct a search always or a search never, instead of trying to suggest this middle ground. So I'm not going to give sort of a doctrinal answer to all questions. Instead, I'm going to say whatever we do, we should not have this sort of middle ground mosaic approach. Why not? And the answer is it's a largely impossible theory to implement, and even if you could implement it, by the time courts could come up with an answer for how, the technology they'd be regulating would be obsolete. As a result, we'd never actually know the answers to any of the questions we'd want to know about what the government can do and when. So think about the question of just what is the mosaic standard. Justice Alito said that the standard is when government conduct exceeds a reasonable expectation of how the police investigate cases. Justice Sotomayor thought the test should be whether the government can see intimate details about people, quote unquote, more or less at will. The D.C. Circuit said the question should be whether the government can do things that a stranger can't in terms of what it can see and aggregate. These are three very different approaches. It's not even clear what the standard of the theory is. Even if you come up with a standard, you then have to ask yourself, what stages does it regulate? Does it regulate acquisition? Does it regulate processing? And then how do you count? How do you count? Is it 7 days of monitoring? Is 21 days enough? If you say there's a certain threshold, what if the government goes 1 day and stops for a week and then does another day and stops? How do you count that? What surveillance techniques does this regulate? Maybe it does GPS. How about cell site? How about pen register? How about visual observation, public cameras? And then what are the remedies? If there's, let's say theoretically the threshold is 7 days of monitoring. If the government monitors for 10 days, is there a remedy only for those 3 days or for the entire time? What if the government uses the technique only to find out where a car is located and then notices the individual is violating a traffic law and makes a traffic stop? Do you suppress the fruits of the traffic stop as a fruit of the mosaic, given that it was only used to monitor that one location? It's possible to generate answers to these questions, although I note no one has ever done it. Even proponents of the mosaic theory have never said that they have answers to how to implement the theory. But even if you tried to devise answers to the theory, by the time you'd come up with these answers, it would take a long time to answer all these issues for each individual technology. And by that time, it's likely that the technology would be obsolete. The government would be using some new tool. And we see this in the location monitoring in Jones. The Knotts case from the 1980s involved radio beepers. No one uses radio beepers anymore. So each technology is only going to be around for a few years. We need a clear rule that answers what the government can and can't do, and the mosaic approach is simply not one that is an effective or usable or implementable method. So that means not that we should have no privacy or less privacy. In fact, we could use my approach to have more privacy. I think the answer may be not to adopt a mosaic approach, but to overturn United States versus Knotts, the underlying case that said that any installation of the device, use of the device in public is not a search. I think there's a fair question as to the scope of that doctrine. Maybe it should be overturned or cut back. But I think the one answer that doesn't work is to have this, we'll see it, we'll take a look, and we'll decide if a mosaic has been created, because even proponents of that theory don't seem to have an answer for how to implement it. Thanks.
Well, I think you make a compelling case that a lot of work needs to be done on this doctrine, but that's typically the case with a lot of doctrines in law, where a lot tends to be not very well defined. That was what was at stake with the reasonable expectation of privacy approach. What's reasonable? What's privacy? But we've used that, and we've hammered out various ways to go about that. And I guess ultimately, you tend to say, well, let's kind of stay with the status quo, even though that's a total mess, rather than going down this rabbit hole, which I agree will probably be a total mess, but maybe a better total mess than the status quo, which I think for a lot of people in the room is not particularly satisfactory, and has led to your theory of like there's 50 billion models of what the court's doing under that test, which is very complex in and of itself. So yeah, this is a complex standard. I think, though, that I don't see why, though, that lines can't be drawn, and ultimately something could come out of this that would hopefully be a bit more sophisticated and concrete over time.
Don't you think it's telling, though, Dan, that no proponent of the theory has ever offered a solution to the problem? That the entire purpose of this meeting was so privacy law scholars could offer suggestions, and no one offered a suggestion? I understand there are complicated standards and there's complicated doctrines, and that's a reality of implementing law. It does seem different, though, to suggest a standard that no one will answer how to apply. That seems to me a whole new level of complexity and ambiguity. It's something we don't want to adopt.
So that was my question. My question was Dan's question, but let me add a gloss that I know a lot of people are thinking about right now. I mean, you and I have traded emails about, you've got this meta theory which basically says when things are really complicated, the Fourth Amendment probably shouldn't embrace it. And so the question, I agree with Dan, is REP, I'm sure, looked that way back in '67. I'm sure a lot of people thought that way. So anyway, but I think the question that I know Susan would ask you if she had the microphone is, why is hers not a test? I mean, I guess you're saying it's not fully specified, these tests that people are offering. I agree that I'm glad Sotomayor didn't sign on with Alito. His test was pretty unworkable and vague. But Susan sounds to me like a test, isn't it, or no? The 4 factors.
So I don't think the 4 factors is a version of the Mosaic theory. It's just a different theory. So I'm not sure. I'm not sure that Susan disagrees with my view. In fact, I took what she said to more or less agree that the Mosaic approach is not workable, and that instead there should be a 4-factor test. So my own point is just whatever you do, no Mosaic, and then we can talk about what else to do.
There's an assumption here by many people that all tests have to be deterministic. But anybody who's a computer scientist or an economist knows that randomized algorithms often work better. And in fact, the kind of games that we get in real life typically have Nash equilibria only if you allow mixed strategies. That's randomized algorithms. So if there's a problem about the number of searches of a particular type, such as GSM location inquiries, that pass the search threshold, a simple solution is to say that there is a 1% probability that you have to get a search warrant if you look up somebody's cell site location. And then if a policeman ends up looking up hundreds of cell site locations for an individual, then with very, very high probability he'll end up having to go and get a warrant. And if he does it only once or twice, then he, with high probability, won't have to get a warrant. But the random number machine on his surveillance kit might very well demand that he get a warrant when he's looking just once. Once you start looking at randomized solutions, many of these arguments against Mosaic approaches, I think, just fall away.
It's a very interesting comment, Oren. I'm sorry, we have to move on. We have Christopher Slebogan appearing virtually.
Hi, everybody. I'm sorry I can't be there. Thanks for arranging this. I have a disadvantage. You can see me, but I can't see you. So if you flip me the bird, I won't know. I've been writing about the kinds of issues involved in Jones for quite some time, and I think what I've written is relatively consistent with the 2 concurring opinions in Jones, but my writing's been pretty theoretical, so I decided to take advantage of this opportunity to try to come up with something more precise that implemented the kinds of things I've been writing about. And I've been influenced in that endeavor by my work with the American Bar Association. I was involved in 2 different task forces, one of which focused on physical surveillance and one of which focused on access to third-party records, or what I call transaction surveillance. What I learned from that experience is that it's very hard to reach consensus, as I think we're demonstrating right now, but also that even if you do reach consensus, which we did reach in the ABA task force, it's very hard to come up with statutory language that can implement what the consensus is. So I really would appreciate feedback on what I've come up with. First of all, the assumption is that privacy should be the linchpin of search analysis, not property, not coercion, not trust, not dignity, not power, not any of the other things that scholars have come up with. I think all of those concepts can be very useful, but I think they're just as manipulable as privacy is. So I think privacy, defined as the ability to avoid intrusion into one's affairs, is the best way of regulating surveillance. And on that assumption, I think if you buy that statement of what I just said, then the word search for Fourth Amendment purposes ought to be defined the way a layperson would define search. That is any government effort to look into, observe, or explore one's affairs, with or without technology. I think that's a key part of my proposal. My proposal is not technology specific. You don't have to worry about what the technology can do, so it responds to a lot of Warren's objections. There wouldn't be any general public use exception. There wouldn't be any knowing exposure doctrine. It's any attempt by the government to look into one's affairs. This, by the way, is the definition I think Scalia would prefer. If you look at what he said in a footnote in Kylo, he drops a definition to the same definition I think Professor Harper quoted a little while ago. But in contrast to what the court would say in terms of Fourth Amendment analysis, I would not say that if something's a search, probable cause is automatically required. That tends to be the approach of the court. Instead, I propose this proportionality principle, which very simply stated is that the justification for a search must be roughly proportionate to the level of intrusion associated with the search. And this is the principle the court already follows. Proportionality is the principle the court already follows in the seizure context. I think it should apply in the search context as well. I think it's probably what Alito was getting at by differentiating between prolonged and short-term tracking. I think maybe it's also something Marc Blitz would sign on to that I couldn't tell for sure. As applied to physical surveillance, that is, for instance, camera surveillance, drones, tracking devices, and so on, what I propose in the statute is that proportionality principle would require probable cause for surveillance that lasts more than 48 hours in aggregate, would require reasonable suspicion for surveillance that lasts between 10 minutes and 48 hours, and then a legitimate law enforcement objective for anything that's less than 10 minutes. Granted, this is arbitrary, but it's an attempt to deal with mosaic theory, or actually the way I like to think of it is it's an attempt to deal with the proportionality principle in this specific context. And as I point out in the commentary that I provided you, there's analogies to this. The court has said, for instance, in Riverside, that the police don't have to take an arrested person to a magistrate until after 48 hours. And they've also said in various stop and frisk cases that a reasonable suspicion authorizes a stop of about 10 minutes, but no longer. The court uses specific time frames in a number of different contexts. For instance, in the interrogation context, it's in the Schatzer case, it's applied a 2-week limit. So this is not out of the blue, this kind of time limitation. For transaction surveillance, the same 48-hour cutoff. For attempts to get information that involves more than a 48-hour period. So for instance, getting phone records over a 1-day period would only require reasonable suspicion. But if the police want a monthly bank statement, they have to have probable cause. That goes over the 48-hour limit. Now, there are other ways of applying the proportionality principle. The ABA task force that I worked on, for instance, tried to identify specific kinds of records that are either more or less private. I happen to think that won't work very well. But in any event, the main point is to try to apply this proportionality principle. I think it does handle some of the problems that Oren talked about. And another advantage of it is...
Chris, I'm sorry to interrupt, but you are going to need to wrap it up shortly.
Okay, so I'll just stop there.
Oh. Perfect.
I got a lot more to say, but I'll stop there.
All right, questions for Chris? Okay, I have one. I mean, I admire how you took from Jones, particularly the Alito decision, to focus on time, but I look at, say, the public targeted search proposal, where you would need a court order based on reasonable suspicion to pay attention to anyone for more than 10 minutes. And I'm wondering how to respond, how you would respond to the sort of, I think, obvious law enforcement concerns about if I perceive someone doing something suspicious and I can't follow them for more than 10 minutes, yet how am I supposed to get a court order to allow me to continue following them? Aren't we going to allow a lot of crimes to pass by?
Sure. Well, there's an exigency exception, just like there is in general Fourth Amendment jurisprudence. So that often would apply, I assume. You don't need a court order if you don't have time to get one.
This is Greg at CDT. If I could just follow up on that. So at the beginning, wouldn't it then be the case for every search that led to something? So you start out with a low level of suspicion and a low trigger, you start observing, and then if something looks interesting and you would trigger the warrant requirement because you went over time, there's no warrant requirement. You're just at the lower level because of the exigency.
I'm not sure I understand.
I mean that you'd never get to the point where you needed a warrant because you would start the observation at the lower level of justification, and it would continue. It would just continue because you found something interesting.
As soon as you reach the 48-hour mark, you'd have to get a warrant based on probable cause. If you track someone for over 2 days, or if you watch someone with the naked eye for over 2 days, you need a warrant based on probable cause. I happen to see those as equally intrusive. Does that answer your question?
All right. Last is Peter Swire presenting for himself and Aaron Murphy.
Hi, my paper is co-authored with Professor Aaron Murphy from NYU. I've never met Aaron, which is sort of significant because she came up with the same doctrinal test working with the same Supreme Court cases that I had independently. And if there's independent discovery or whatever, maybe there's something there. I don't really know. So the this sort of procedural approach starts with the following question. Who here thinks for new technology the government should have standardless and unconstrained discretion? Who's in favor of standardless and unconstrained discretion? This is what's known as a loaded question, right? Paul Ohm does, but he wants to comment on it, but we'll get that in. Okay. So the general warrant problem, the Fourth Amendment problem, has to do with what Justice Sotomayor called unfettered discretion. And it was a little bit the question in Jones when one of the justices asked, so government, does that mean we could put GPS trackers on each of the justices' cars? And the Justice Department answered back, well, yes, that's our theory. You're in public, we can do that. And in that kind of world, the court somehow answered back. And I think what they were answering back to is this sense of there needs to be some limit somewhere. And I think something besides probable cause warrants should be part of the mix. So in our work, we looked at the sobriety checkpoint cases. You know, you're driving home on Saturday night, the cops pull you over. The Supreme Court has said they can't just pick out anybody they want there. There has to be procedures in place. So they pull over all the pretty women or all the blacks or all the people in red cars. That turns out to be a Fourth Amendment interest. And the lack of procedures that are being followed means that there's a Fourth Amendment concern. We have to be careful there. And that idea of having limits on constraint applies to opening closed containers. It applies to minimizing when it comes to wiretaps. And so we have Supreme Court precedent for this. And so the rule at the highest level is that the test here should be for these searches in public and other new technologies, it should be the reasonableness under the Fourth Amendment of adequacy of and compliance with procedural safeguards. Are the adequacy of the safeguards and the compliance with it reasonable? Fourth Amendment has a general reasonableness test. That's what we're looking at. And so in our paper, and you can see it, we lay out 4 pieces of that I think are common sense and that judges are well equipped to do. The first of these is to say, is there a constitutional interest here? Is there enough of the sort of organized searching and seizing going on here that we should have procedural concerns? That could be lower, at a lower threshold than for probable cause warrants. And the courts could say, you know, this new drone thing, this new, special camera thing, there's enough going on here, we should look at it. Step 2 would be then, are there procedures to limit the discretion? Have they come up with some procedures for what's okay and what's not? They could take Chris Lobogan's 48 hours. They can do mosaic theory under their own rules, how they want to do it. But they get to do it, they meaning the police and the legislature. Step 3, are those limits considered as a whole reasonable? It's a reasonableness test. And step 4, of course, is were the limits actually followed in this case. This can be tested at trial after the fact. If it looks like there was crazy drone surveillance with no limits, the defendant gets to say there was crazy drone surveillance with no limits. That's unreasonable what happened here. And in the cases where it's unreasonable, a relatively small subset, the courts say that's unreasonable, and we build up a body of law of where you need to have these limits. So this could go alongside good old-fashioned probable cause warrants with searches. As I said, it builds on the competence of the branches. So the political branches get to design the procedures, regulatory sort of things, PIAs or whatever you want to call it. And the judges have a judicial job of, are these procedures good enough and that they follow them here? Judges don't have to be high-tech whizzes here. They have to look at a sort of administrative review of the whole thing. There's not only Supreme Court cases here, the reasonableness has been built into Fourth Amendment jurisprudence and DNA testing and FISA and school searches and others, not just a warrant, there's 2 clauses to it. There's academic roots to this in the work of Akhil Amar and Anthony Amsterdam, and perhaps interestingly, Article 8 of the European Convention on Human Rights actually has this regime more or less in Europe. That doesn't mean we should follow European law because it's European law. We're not going French. But it is worth noticing that a large established set of countries working on surveillance have faced these issues and come up with this sort of procedural regularity approach. So I think this way we would get reasonable particularity in procedures. They'd be transparent because they'd be tested at trial. We get to see what the police procedures were. And in the end, we'd be doing what the judges can do best and what the cops can do best and put some constraints on otherwise limitless discretion.
Thanks a lot, Peter. Questions for Peter about his approach?
Kevin, I've got a question.
Yes, Chris.
Since I didn't get to talk about this part of my proposal, I'm going to use this as
the part that's similar perhaps to my proposal. Go ahead.
Exactly. I wanted to ask you about what you thought about that part of my proposal.
It was brilliant to the extent it paralleled ours. No, right. I'm sorry. Go ahead, Chris.
Well, go ahead. Go ahead if you have something to say.
No,
a proposal that deals with general searches. So in other words, the police want to set up drone surveillance of an entire city, or they want to have cameras throughout a particular municipality, or total information awareness, data mining involving accumulation of large amounts of information. And I think what I propose is similar to what you're proposing in terms of having legislative authorization for that kind of thing and restrictions on the extent to which information can be gathered.
Chris, I respect your work very much and have read a lot of your writings, and I was encouraged when I saw that general search part in the summaries here. It may well have been that I've seen it before, and that could be some footnote that I didn't realize was building into what I was writing. So the general search, I think, is very similar. It's this instinct that there should be some procedural regularity and some participation by the political process in writing the rules, and then judges at some point test it for overall Fourth Amendment reasonableness.
Question. For years, I think Orrin and Dan had kind of a back and forth about competence between judiciary and legislature. And I have to say, I think Alito cribbed Dan without credit in the end, right? When Dan's realization to me, which seemed very plausible, is basically, I won't say it as well as he does, I'm sure, but it would be better if legislatures took the first stab and then courts could just review it for reasonableness. But what happens when legislatures haven't done that, right? Then it is a constitutional responsibility of the courts to step in and do that as a first instance. And I guess I would just ask what you think about that. In other words, I see yours maybe as a best possible if a legislature will step in or a police department will step in and make these rules. But if they don't, is there some constitutional responsibility of the courts to create a test in the absence of another institutional actor doing that?
Yeah, so there's a Michigan Law Review article by Orrin. I wrote one of the responses, Dan wrote another responses, and that's the first place I sort of laid this out in 2005 or whenever it was. So I think when there's no procedures and it's one of these unconstrained discretion things, then there's not reasonableness in this case. Now, I haven't worked through exactly what the exclusionary rule and consequences are, and we'd need better criminal procedure people than I am to work through all of that. But at that moment, there would have been a violation of the constitutional rights, and the Fourth Amendment kicks in the way I would approach it.
Okay. Thank you, Peter. We have a little less than 15 minutes for questions and comments and final voting. I would encourage folks who submitted papers but didn't get to present, if you want to, elucidate your theory, you can do that. If you want to poke holes in these folks, you can do that. If any of the panelists want to engage in a dialogue over each other's ideas, now is a good time for that. But anyone, Dan?
Throw something out as food for thought. I mean, before this opinion, I actually wrote a piece calling for the abolition of reasonable expectation of privacy. I grew fed up with it. I basically thought that too much attention is going into the what is the search question, and not enough is going into the overarching question is how do we want the police to be regulated in what they're doing? So I ultimately proposed that we kind of tried to propose a way to jettison almost the first question to say, anytime there's a problem, because it's not just privacy, it's all sorts of other interests as well, and we shouldn't focus so much on privacy. I mean, I like the idea of the mosaic theory's broad understanding of privacy, but if we just focus more broadly than that, ultimately, a lot of people criticize me because vague courts could take that and narrow that. I mean, the whole point I was trying to get is almost jettison what is the search question so we can get to the better question, which is what should we do? And then ultimately, if we jettison the rule that it always has to be a warrant, let's say, and really try to focus on, okay, how should the police be regulated in this particular types of conduct, and really focus on that second level question, and then what's the reasonable level of oversight for the various things the police do, I think that's a much, much better approach, and we don't even have to get to the first question. I probably should have said that more clearly and even eliminated the first threshold question. So I would kind of propose maybe we just don't even answer this question. Mosaic theory is really nice, but ultimately, why don't we just always just assume that we need to ask a question of does this need oversight, and if so, how?
Paul, were you?
So thank you. I'm not going to talk about my proposal. I'm still crushed by the failure to be one of the final six. But because there is a, and I mean this with respect, but because there's a vague reality show feeling to the end of this, let's ask a reality show type question to each of the six people. Let me ask two. Question one is, under your reconception or test, would you have to overrule knots? Right? And if you can't answer that, that might feed into Oren's idea that this is all too complicated. Question two, turn to the five around you and pick the person who you think is the second best proposal next to yours.
I like the way you think, Paul. Okay. Professor Blitz, you first.
I'm trying to remember the facts of knots, but based on the memory I have, yes, I think so. I think that the one thing that could save knots, I suppose, is that there was a claim there that the beeper technology really, if I'm remembering correctly, the argument was it's a small part of what was conducted primarily with just policemen using their eyes and following in the car. So unlike the GPS technology, which was absolutely necessary, I think it'd be hard to save knots. And so I guess to the extent the concurring opinions are trying to set things up so that they can simultaneously save knots, that's a tension with those opinions.
In the interest of time, I'd like to move on to the others, and if we could keep the knots answer ideally to a yes or no, but well, that's ridiculous. But a few sentences would be good, because Paul at this point has filled up the rest of the time with this question. So let's zip along.
Well, Susan's sitting right next to me and could hit me if I give another response. So.
And she will.
Okay. Very quickly, I think knots falls under the hidden, continuous, intrusive, indiscriminate test. So I would say it should be overruled. Which raises the question, is visual surveillance generally covered? I think it is. I like the idea that if you're targeting someone for surveillance, then you should get a warrant. I don't think a warrant that's hard to get. I think if you're hiding your surveillance from someone and targeting them as they go about their business, you should have a warrant. You should have reasonable, probable cause for that. I like Marc's paper, the second best.
So on a brief, I would just say, you can distinguish it. Oren said there's nobody using beepers anymore. Or you could ignore it, but I think on the merits, you'd have to overrule knots. I think Oren Kerr's paper is second best. The mosaic theory is the same mess that reasonable expectations has us in.
So I guess my own view is the issue is whether you want to overturn knots, and so I don't really have a view on it. I don't think it matters on its facts, because the facts never arise anymore. And my second favorite paper is Marc Blitz, although all of these were wonderful presentations, and it's an honor to be here with everyone. Even the papers that were not picked, some of them were even better, especially yours, Paul.
I would overturn knots because clearly a search was involved there, but I don't want to require reasonable suspicion. I think one of the problems the courts had is as soon as something is called a search, probable cause required, which has led the justices, including the liberal justices, to say a lot of police action is not a search at all because they're scared that would require a probable cause. And so now I'm more or less with Dan Solak on that. On which proposal I like, if we're talking targeted searches, I like Susan's. If we're talking general searches, I like Peter's. But I like mine best.
Okay. Oh. So knots didn't have procedures in place, so it wouldn't be reasonable. And I'll point to Woody Herzog's obscurity paper and Catherine Strandberg's tests, and there were two student papers that had tests as additional doctrinal sort of responses to the call that I think are worth careful consideration by people.
So I wanted to make a comment. I hate to be the stats person all the time, but we know so little about the methods that the government is using to spy on us, or at least the scale of these things, that when the courts and Congress think about examining them, they don't seem very urgent. They seem like they're obscure technologies that are not being used very often. I mean, you look at the Jones argument, and even post-Jones, we still don't know how often GPS tracking devices are used nationwide. We know the FBI numbers, but we don't know state and local law enforcement agencies because they don't publish those stats. Last week, Congressman Markey received letters from all the wireless carriers detailing how many times they get requests from law enforcement agencies. At some point, those letters should be public, and I think that will freak everyone out, because I think the numbers that are contained in there will reveal that these are not things that are used, a few hundred times a year on the worst of the worst. But I think one of the reasons why Congress hasn't felt the urgency to deal with this is because they feel like this is a technology that's used rather sparingly on only criminals. And if this turns out to be used on a lot of innocent people, as the numbers will likely suggest, even though the numbers won't say these are guilty and these are innocent, but just the pure scale of the numbers, I think Congress might feel a bit more of a desire to do something about it.
All right. Steve Bellivin's got a question.
Oren, I think your paper's more saying Mosaic doesn't work rather than what should be done, but I'm particularly disturbed by the lack of, I don't see any good way to deal with Kilo in this world without Mosaic, because technology is just not just getting more intrusive, it's much more economical. If we envision once upon a time you might have needed a $100 million spy satellite to track somebody, now it's just a letter to a cell phone company which already got these wonderful tracking devices all over the place. We call them cell towers. We're coming back to a general warrant. We're going to have to come something that's more information based, just because the economics of search are getting so persuasive to the police. Without oversight, how would you distinguish this from Kilo? This technology is becoming more popular with Foursquare, with GPS trackers monitored to parents who are worried about their children or their teenagers or their Alzheimer's parents. How do you deal with this?
So I think there are two distinct questions. One is the Mosaic theory, and the other is more generally, how does the Fourth Amendment respond to technological change? So I think the Mosaic theory is not an effective way of responding to the problem, but the other way of responding to the problem is the traditional thing that courts have done, which has been when technological change expands government power, the Supreme Court tweaks the rules to add Fourth Amendment protections to bring the level of government power back to more where it was before. And a really good example of this is Katz. Katz overturns Olmstead, and the thought behind that, I think really the animating principle is, in our new technological world, we need a rule that regulates telephone surveillance because the telephone has taken on such an important role in society that it didn't in the era of the 1920s. So I think that method should continue, and I don't have sort of a turn the crank answer to exactly how that method should continue. But that basic idea is what the courts have done. This is something I've called in a recent paper equilibrium adjustment, sort of restoring, changing the level of Fourth Amendment protection in response to changing technologies. And I think that process should continue, but it's critical to realize, Katz didn't say, you can listen in on the phone call for maybe a while, but then at some point you shouldn't listen in, and 28 days of listening in is too much, but we're not going to say where the line is. They said listening in is a search, you need a warrant done, and so it's that sort of binary thinking that I think is the way to go.
45 years between Olmstead and Katz?
All we need is another 45, we'll be good. I want to take a minute to answer your question, because for me it implicates the third-party doctrine. We're using lots of technologies, but we're using them basically subject to unobserved terms of service and contracts and regulations. And so when my article comes out, I'm going to write a companion piece for the National Association of Criminal Defense Lawyers, inviting them to start collecting that information and putting it in at the trial phase. What was the contract governing the terms of service? What were the representations the company made in addition to the terms of service, so that we can build cases where the law that they've used to protect their privacy comes in and gets considered. We're going to have to knock down the third-party doctrine, which completely disregards law and contract.
All right, on that note, we are out of time. I want to thank our presenters. I want to thank everyone who put in a paper. We are still, and thank you, Chris, for being able to call in. We are still trying to decide how best to leverage all of this great work, and if you have any suggestions about how this project should move going forward, we'd love to hear them. There is also an ability to comment on the proposals at the website. We encourage that as well. Thank you so much, and thanks again to Dan and Chris for letting us do this.